Roman Canon Law 3.3 Rights Suspension and Corruption Article 100 Cestui Que Vie Trust. 6 January 2015 at 14:29. Exclamation mark exclamation mark exclamation mark. Pay attention. Canon 2036. A Cestui Que Vie Trust, also known by several other pseudonyms such as Term of Life or Years, or Per Autre Vie, or Five Commissary Trust, or Foreign Cities Trust, or Secret Trust, is a pseudo-form of trust first formed in the 16th century under Henry VIII of England on one or more presumptions including, but not limited to, one or more persons presumed wards, infants, idiots, lost or abandoned at sea, and therefore assumed presumed dead, after 7 years. Additional presumptions by which such a trust may be legally formed were added in later statutes to include bankruptcy, incapacity, mortgages and private companies. Canon 2037. In terms of the evidential history of the formation of Cestui Que Vie Trusts, the first Cestui Que Vie Trusts formed were through an Act of Henry VIII of England in 1540, 32 Hen. 8 circa 1, and later wholly corrupted, whereby the poor people of England, after having all their homes, goods and wealth seized in 1535 27 Hen.8 c.28 under the guise of small religious estates under £200, were granted the welfare or commonwealth benefit of an Cestui Que use or simply an estate with which to live, to work and to bequeath via a written will, and in 1666 Westminster and the ruling classes passed the infamous Proof of Life Act, also called the Cestui Que Vie Act 19 Car.2 c.6, whereby the poor and disenfranchised that had not proven to Westminster and the courts they were alive, were henceforth to be declared dead in law, and therefore lost, abandoned and their property to be managed in their absence. This supremely morally repugnant act, which remains in force today, is the birth of Mundi and the infamous occult rituals of the British courts in the wearing of black robes and other paraphernalia in honouring the dead, and in 1707 Westminster under Queen Anne 6 and c.18 extended the provisions of Proof of Life and Cestui Que Vie, extending the use of such structures ultimately for corporate and other franchise purposes. This wicked, profane and completely sacrilegious act in direct defiance to all forms of Christian morals and rule of law has remained a cornerstone of global banking and financial control to the 21st century, and in 1796, King George III 36 Go.3. c.52 Section 20 duty was applied to estates per autre vie for the first time, and in 1837 1 Vict. c.26 and the amendments to the nature of wills, that if a person under an estate per autre vie Cestui Que Vie did not make a proper will, then such property would be granted to the executors and administrators. Canon 2038. In terms of the evidential history of the operation and any form of relief or remedy associated with Cestui Que Vie Trusts, taking into account all statutes referencing Cestui Que Vie prior to 1540 are a deliberate fraud and proof of the illegitimacy of Westminster statutes. The first Act outlining Cestui Que Vie Trusts is deliberately hidden under the claimed statutes of the reign of King Richard III in 1483, 1 Rich.3 c.1, whereby the Act, still enforced, states that all conveyances and transfers and use of property is good, even though a purchaser may be unaware it is effectively under Cestui Que use, subject to a Cestui Que Vie Trust. The Act also gives a vague and challenge path of relief that if one is of complete mind, not an infant and not under financial duress, then any property under Cestui Que Vie Trusts is rightfully theirs for use, and the second Act outlining Cestui Que Vie Trusts is deliberately hidden under the reign of Henry VII in 1488, 4 Hen.7 c.17, permitted lords to render any attempt by people classed as wards to demonstrate their freedom useless, and that such lords may use writs and other devices to force such people back to being compliant, wards, poor slaves. The only remedy under this act was if a ward demonstrated the waste of the lord as to the property and energy seized from the poor, ignorant white slaves, and the third Act outlining the operation of Cestui Que Vie, only hidden this time as estate per autre vie, was in 1741 under 14 Go.2 c.20, whereby one who was knowledgeable of the Cestui Que Vie slavery system could between the ages of 18 to 20 seek to recover such property under Cestui Que Vie and cease to be a slave. However, the same act made law that after 20 years, the remedy for such recovery was no longer available, despite the fact that the existence of Cestui Que Vie trusts is denied in Westminster and banks are sworn to lie, obstruct, hide at all cost the existence of the foundations of global banking slavery. Canon 2039. In terms of essential elements concerning Cestui Que Vie trusts, a Cestui Que Vie trust may only exist for 70 years being the traditional accepted life expectancy of the estate, and a beneficiary under estate may be either a beneficiary or a Cestui Que Vie trust. When a beneficiary loses direct benefit of any property of the higher estate placed in Cestui Que Vie trust on their behalf, they do not own the Cestui Que Vie trust and are only the beneficiary of what the trustees of the Cestui Que Vie trust choose to provide them. And the original purpose and function of a Cestui Que Vie trust was to form a temporary estate for the benefit of another because some event, state of affairs or condition prevented them from claiming their status as living, competent and present before a competent authority. Therefore, any claims, history, statutes or arguments that deviate in terms of the origin and function of a Cestui Que Vie trust as pronounced by these canons is false and automatically null and void. Canon 2040. The trust corpus created by a Cestui Que Vie is also known as the estate from two Latin words e plus statuo literally meaning, by virtue of decree, statute or judgment. However, as the estate is held in a temporary not permanent trust, the corporate person as beneficiary is entitled only to equitable title and the use of the property, rather than legal title and therefore ownership of the property. Only the corporation, also known as body corporate, estate and trust corpus of a Cestui Que Vie trust possesses valid legal personality. Canon 2041. The property of any estate created through a temporary testamentary trust may be regarded as under Cestui Que use by the corporate person, even if another name or description is used to define the type of trust or use. Therefore, Cestui Que use is not a person but a right and therefore a form of property. Canon 2042. In 1534, prior to the first Cestui Que Vie Act 1540, Henry VIII declared the first Cestui Que Vie type estate with the Act of Supremacy which created the Crown Estate. In 1604, 70 years later, James I of England modified the estate as the Crown Union of Crowns. By the 18th century, the Crown was viewed as a company. However, by the start of the 19th century around 1814 onwards upon the bankruptcy of the company 1814/15, it became the fully private Crown Corporation controlled by European private banker families. Canon 2043. Since 1581, there has been a second series of Cestui Que Vie estates concerning the property of persons and rights which migrated to the United States for administration including in 1651 the Act for the Settlement of Ireland 1651-52 which introduced the concept of settlements, enemies of the state and restrictions of movement in states of emergency, and in 1861 the Emergency Powers Act 1861, and in 1931 the Emergency Relief and Construction Act 1931-32, and in 2001 the Patriot Act 2001. Canon 2044. Since 1591, there has been a third series of Cestui Que Vie estates concerning the property of soul and ecclesiastical rights which migrated to the United States for administration including in 1661 the Act of Settlement 1661-62, and in 1871 the District of Columbia Act 1871, and in 1941 the Lend-Lease Act 1941. Canon 2045. By 1815 and the bankruptcy of the Crown and Bank of England by the Rothschilds, for the first time, the Cestui Que Vie trusts of the United Kingdom became assets placed in private banks effectively becoming private trusts, or fidecommissary trusts, administered by commissioners guardians. From 1835 and the Wills Act, these private trusts have been also considered secret trusts, whose existence does not need to be divulged. Canon 2046. From 1917/18 with the enactment of the Sedition Act and the Trading with the Enemy Act in the United States and through the United Kingdom, the citizens of the Commonwealth and the United States became effectively enemies of the state, and aliens, which in turn converted the fidecommissary, private secret trusts to foreign cities, private international trusts. Canon 2047. In 1931, the Roman cult, also known as the Vatican, created the Bank for International Settlements for the control of claimed property of associated private central banks around the world. Upon the deliberate bankruptcy of most countries, private central banks were installed as administrators and the global Cestui Que Vie foreign cities trust system was implemented from 1933 onwards. Canon 2048. Since 1933, when a child is born in a state under inferior Roman law, 3 Cestui Que Vie trusts are created upon certain presumptions, specifically designed to deny the child forever any rights of real property, any rights as a free person and any rights to be known as man and woman rather than a creature or animal, by claiming and possessing their soul or spirit. Canon 2049. Since 1933, upon a new child being born, the executors or administrators of the higher estate willingly and knowingly convey the beneficial entitlements of the child as beneficiary into the first Cestui Que Vie trust in the form of a registry number by registering the name, thereby also creating the corporate person and denying the child any rights as an owner of real property. Canon 2050. Since 1933, when a child is born, the executors or administrators of the higher estate knowingly and willingly claim the baby as chattel to the estate. The slave baby contract is then created by honoring the ancient tradition of either having the ink impression of the feet of the baby onto the live birth record, or a drop of its blood, as well as tricking the parents to signing the baby away through the deceitful legal meanings on the live birth record. This live birth record as a promissory note is converted into a slave bond sold to the private reserve bank of the estate and then conveyed into a second and separate Cestui Que Vie trust per child owned by the bank. Upon the promissory note reaching maturity and the bank being unable to seize the slave child, a maritime lien is lawfully issued to salvage the lost property and itself monetized as currency issued in series against the Cestui Que Vie trust. Canon 2051. Each Cestui Que Vie trust created since 1933 represents one of the 3 crowns representing the 3 claims of property of the Roman cult, being real property, personal property and ecclesiastical property, and the denial of any rights to men and women, other than those chosen as loyal members of the society and as executors and administrators. Canon 2052. The 3 Cestui Que Vie trusts are the specific denial of rights of real property, personal property and ecclesiastical property for most men and women, corresponds exactly to the 3 forms of law available to the Gala of the Bar Association courts. The first form of law is corporate commercial law is effective because of the first Cestui Que Vie trust. The second form of law is maritime and trust law is effective because of the second Cestui Que Vie trust. The third form of law is Talmudic and Roman cult law is effective because of the third Cestui Que Vie trust of baptism. Canon 2053. The birth certificate issued under Roman law represents the modern equivalent to the settlement certificates of the 17th century and signifies the holder as a pauper and effectively a Roman slave. The birth certificate has no direct relationship to the private secret trusts controlled by the private banking network, nor can it be used to force the administration of a state or nation to divulge the existence of these secret trusts. Canon 2054. As the Cestui Que Vie trusts are created as private secret trusts on multiple presumptions including the ongoing bankruptcy of certain national estates, they remain the claimed private property of the Roman cult banks and therefore cannot be directly claimed or used. Canon 2055. While the private secret trusts of the private central banks cannot be directly addressed, they are still formed on certain presumptions of law including claimed ownership of the name, the body, the mind and soul of infants, men and women. Each and every man and woman has the absolute right to rebuke and reject such false presumptions as a member of one heaven and holder of their own title. Canon 2056. Given the private secret trusts of the private central banks are created on false presumptions, when a man or woman makes clear their live-born record and claim over their own name, body, mind and soul, any such trust based on such false presumptions ceases to have any property. Canon 2057. Any administrator or executor that refuses to immediately dissolve a Cestui Que Vie trust, upon a person establishing their status and competency, is guilty of fraud and fundamental breach of their fiduciary duties requiring their immediate removal and punishment. The slavery system. Whether we realized it or not, until recently, we were all, legally, debtor, labor, slaves, as were our parents, our grandparents and great-grandparents before us. Since 1933, every new child born was required to be registered, thereby creating a corporate person, effectively denying that child any rights as an owner of real property. The act of registering a child contracted him as chattel, and the birth record was a deceptive legal way of getting the parents to sign the baby away. The birth record was in fact a promissory note that was converted into a slave bond, which was then sold to a private reserve bank, effectively giving ownership of the child to the bank. Each new baby's contract was sealed by either a drop of their blood or by an ink impression of their foot onto the birth record. This signature was used to create their lifetime value, evidenced by their labor and the taxes and costs of that labor as monetized currency, all designed to keep people in servitude for their entire lifetime. The banks have been the modern slave owners, and as the saying goes, he who owns the debt owns the people. The way the slavery system was imposed on us meant that even if we did end up paying off our house or our car, we never actually owned it, because our right to any real property ownership was given away at the registration of our birth. This has been legal process since 1540 via something called a Cestui Que Vie Trust, and this was still in effect until the recent UCC rulings changed the legal landscape and reinstated the unrebuttable fact that no one can own ourselves or own our bodies. The slavery system remained intact for so long because of educational doctrines, the influence of our community at large, and because so many people accepted and embraced their slavery by waiting for others to help them or to tell them what they could or could not do. Enforcers like the police and courts made sure we stayed within the slavery system and incarcerated us if we chose to live as free individuals. In fact, the slavery system was imposed on us all and maintained for centuries by building walls in our minds through propaganda and conditioning, creating the false belief that we did not deserve better, that we were not part of a greater plan, and that we should instead be happy with the handouts, crumbs and indulgences given to us by the powers that were PTW, while the system itself reaped in millions of dollars every year directly from the sweat and blood of our labor. But no more. Source: Cestui Que Vie Act 1666. An act for redress of inconveniencies by want of proof of the deceases of persons beyond the seas or absenting themselves, upon whose lives estates do depend. Legislation. Gov. UK.